My name is Anil, Karia. I'm a lawyer. I'm based out of Portland. Don't hold that against me. I grew up there. All of my investments and my retirement are there in the form of land holdings, so I am screwed. No, they're not graffiti, because I live in the nice part of town, man. I got to the other side of the tracks. I actually do have private security now. I've represented police unions, guilds, associations since July 1st of 2019, when I left the hallowed grounds of corporate law and all the rainbows and unicorns in that world to come represent you all. It's been always an honor and a pleasure not only to work with many of your groups, but also to work with Teresa and her team with WACOPS. And so thank you for having me. Usually I'm in Vegas speaking, and so there's like this faint smell of cheap vodka every morning. I like Walla Walla. It's my first time here, actually, because it smells like a nice Malbec in here this morning. So thank you for that also. Here's what the slate is for us today. We're going to walk through a lot of the pieces of legislation that came out of the last legislative session. My goal is to try to give you all a high level of understanding of what the pieces of legislation did. That's point number one. I will admit to you, not only did I work with Teresa, members of the GRC, your lobbyist, Jeff DeVere, on these in real time. There were 3 other lawyers in my office working on these pieces of legislation in real time. Notwithstanding the fact that I worked on the legislation, I have read it all, I still don't understand like 80% of it, right? I'm still figuring this stuff out. I think all of you are too. And so here's the second part of it. I would love to have you all in this room speak up and talk about the implementation of 1310, for example, on the ground in your jurisdiction. What's your agency doing? How is your guild working through this and implementing it with your agency? Because here's the thing, I can stand up here for 5.5 hours and dazzle you with lawyer words, or you guys can get something and take it back home to work on, right? And I will absolutely tell you, taking some of the pieces of information you're going to get out of me today and the other folks in this room is what's going to help you locally, right? I can lecture to you all day long. I can see those eyelids start drooping probably around 10:30, right? Or you guys can interact with me. But here's the kicker. I'm a power player. So that means that if you're not interacting with me, I will drag my ass out to you and interact with you. And that's just totally random, and that's super awkward for you, right? Or please, in all seriousness, let's talk through this stuff together. And I'll give you an example of where I'd love to hear from you all, because it actually helps me. One of the pieces of 1310 that we'll talk about, and all of you probably have very strong opinions about, is they have moved the dial for you guys to actually start engaging with people, right? Probable cause is now our standard. Reasonable suspicion bar has been moved. How is your local agency or your local guild or association interacting with the public to educate the public about why that's a flawed public policy? Or are you not doing that? Have you seen other places do it? Because there are ways to influence what we should also be looking at, which is not just sitting back and saying to ourselves, well, we got pummeled in that legislative session, which we did. But we should be thinking about how we can fix some of this stuff. Now, I'm not going to lie to you. I'm not going to tell you that we're going to be able to go to the next legislative session and say, tear up everything that you did, Olympia. That's not going to happen, right? Teresa is very good at what she does, but she's not a miracle worker. But what we may be able to do are take pieces of that legislation, in 1310, for example, since we're talking about it, and get some fixes to it. Get some tweaks in there. Those takeaways, what you guys are experiencing locally, is what's going to help arm Teresa, what's going to help arm the GRC of WACOPS for the next legislative session to have some fixes in hand for some of these turds that they called legislation, right? Okay, with that in mind, let's talk about some baseline labor law concepts. First of all, we've got hierarchies of law. Federal law is supreme. Then there's state law. What we're going to be talking about today is state law changes. Then you've got local. You've got city charters, you've got county charters, you've got city codes, county codes. Our friends in Spokane will tell you how aggressive locally they have been using their local charter and code to try to change and manipulate the working condition and collective bargaining process. And I think civilian oversight's the big one for you guys, right? Agency policies and procedures. Every single one of these pieces of legislation will include changes to local policies, your PD policies, your SO policies. And then you've got your contract. But here's the question. What happens when a conflict arises between all of these bodies of law? Right? Well, we know federal law takes supremacy, right? So think about it this way, though. Federal law tends to be a floor. The Fair Labor Standards Act has 2 rules in it. Did you know that? Will Aitchison, my law partner, drives a Tesla based on 2 rules, which pisses me off because he's figured out how to game the system. Right? There's 2 rules. There's a minimum wage law, and then there's an overtime rule. Do you guys get paid higher than minimum wage? Yes. You're in compliance with federal law. Does your contract overtime clauses outperform the Fair Labor Standards Act overtime rules? 28-day cycle, 171 hours. Do you guys get paid for overtime if you work an extra hour at the tail end of your shift? Yeah, right? We've met the floor of federal law. Then there's state law, right? State laws have to comply with federal law, but state laws downstream can influence what's happening locally, and more importantly, the state laws can impact our collective bargaining rights as organizations. Think about it this way. Where do all of your organization's collective bargaining rights come from? What statute? You guys had better answer up because you're literally right in my line of fire, right? The Public Employee Collective Bargaining Act, RCW 4156. What is that? It's a state law. Who wrote the state law? State legislature. Who can change the state law? State legislature, right? The state can giveth and taketh away. And if the state taketh away, what happens to your local collective bargaining agreements? Pieces may become unenforceable as violating state law. That's what we're dealing with, right? This is happening all over the country to police and police collective bargaining. I practice in 3 states. I practice in more states. Legally, I practice in 3 states. Oregon, Washington, and Alaska. Even the state of Alaska, which loves they may not have ever met you, but they love you by default, came close to police reform legislation. Think about that political dynamic. Okay, a couple more collective bargaining basics. We've got demands to bargain. Remember, you've got a collective bargaining agreement. You signed that collective bargaining agreement. Is your bargaining done? No, you've got a continuing duty to bargain. The employer and the labor organization have a continuing duty to bargain when there are midterm changes in working conditions. Do you think these state laws have changed some working conditions? Uh-huh. Right? So how do you assert that bargaining right? You send a demand to bargain. Well, demand is a sort of a weird word. It's a technical term of art. Right? Basically what you're doing is you're asserting collective bargaining rights. You may be doing that preemptively. You may be simply notifying your chain of command and your bargaining agents for your employers that we are aware that the legislature has changed a whole bunch of stuff, and with this email we are asserting our collective bargaining rights over changes to working conditions, including what sort of things? Do you think any of these changes have impacts on discipline? Yeah, that's like the entirety of what they were trying to do, right? Do you think a change in the use of force policy impacts your members' working conditions? Uh-huh. Super simple way to explain to management why you care. What happens if there's an excessive force policy violation with these overlay of these laws? Do you think the state set it up to remediate and help officers improve and not make that mistake again? No, they set it up to terminate you, right? And so we have to work locally on these rules, and the way to get your foot in the door is to assert your collective bargaining rights with a demand to bargain. Here's, for my practice, the way I handle a demand to bargain. The demand to bargain is just putting a marker out on the table. And at that point, then it becomes collaborative and practical. You know why? Let me ask you this. What happened in the legislative session in terms of style of legislating? They legislated to you as a profession, not with you, right? You saw the outcome when you were legislated at, not good outcomes. If you can bargain with the employer to make sure that these policies are good, strong policies that protect your members, their officers, we're talking about the same groups of people. Remind your chain of command that. Their officers, their deputies are your members. It's the same people. We're just coming at it from a slightly different lens, a slightly different angle. You can work collaboratively and proactively to better ends. And I know that because I've had experience doing it the other way, which is to punch each other in the face for 3 years. What happens in the interim while you're punching each other in the face? Members are getting screwed, right? That's not to say that there's going to be times where there are going to be times you're going to fight over something. I get that. I'm not Pollyannish. But you guys, as organizations, to the degree you're trying to be proactive, can step up and say, we want to work with you, management, to work on these things. I'll give you an example. One of your members in the room is with Vancouver PD. Vancouver PD sat down with the Guild, and guess who wrote their new force policy? We did, for them. I'd much rather write the force policy for them than have them write a force policy for us and then tinker with the edges, right? Okay, what else do we have? Well, we've got grievances and unfair labor practices. Let me give you just a very quick explanation of what these are. A lot of you are experienced representatives in your labor organizations. Some of you may not have as much experience, so forgive me if I'm telling some of you something that's self-evident. But a grievance is a violation of a collective bargaining agreement or a set of well-established past practices under the collective bargaining agreement. Right? An unfair labor practice is something different. An unfair labor practice is a violation of the Collective Bargaining Act, and in particular, in this context, the employer's duty to bargain in good faith with the labor organization in question. How does that manifest itself in legislative changes? Well, there's two types of bargaining out there. There's decision bargaining and there's effects bargaining. Decision bargaining is, we are going to change our force policy. The effects bargaining is, how does that force policy change impact the working conditions of your members? When you have state level changes, you cannot bargain over the decision. Do you know why? Because you got to comply with state law now. That has changed the dynamic, the bargaining dynamic for you all in terms of leverage. Bargaining is leverage, right? If you can bargain over the decision itself. How many here in this room have bargained over body cams? Lots of people, dash cams, body cam systems. In Washington, videoing and audio recording employees during the course of their work is negotiable, and the decision itself to have those systems is negotiable. It's a form of employee surveillance. But if the state legislature passed a law that said every law enforcement agency in the state has to have body cams, let me ask you how the bargaining dynamic changes. For those of you who bargained body cams, did you sit down at the table and said, well, first instance, you have to convince us that body cams are a good idea? Do you think that's different than, we're going to get body cameras, now we simply just want to bargain over what the policy says? If you're trying to monetize a body camera program, given the changes and impacts on your membership, how do you think that dynamic changes if you only can bargain over the impacts or the effects of that and not whether to have it in the first place? It completely changes the bargaining dynamic. Right? Do you think you're going to monetize something that the employer's representatives are going to say to you, I don't have to pay you shit, guys. The state's telling us we're getting this program. We're getting it. We'll bargain with you about how it's going to work, how it's going to be used for discipline. Is it an always-on policy? Is it a discretionary activation, deactivation? We'll bargain with you about that. But good effing luck getting a dime out of us, because you're getting it. We don't have to convince you through the bargaining process whether to have it or not. So understand, with a lot of these changes from a collective bargaining standpoint, a lot of the bargaining is going to be, look, we're going to be on our heels, basically, just dealing with stuff, just trying to absorb stuff, just trying to check stuff off the box to make sure these little tweaks to policies are not going to screw our members, right? That they're going to have a fair shake in how they're conducting their profession. Back to the collective bargaining agreement impacts, just a couple of things to watch out for. Some of these pieces of legislation, we'll talk about the arbitration bill, for example, will require, as a matter of state law, changes to collective bargaining grievance procedures, right? So you've got grievance procedures and contracts that explain to you how to handle a grievance, which is a dispute about the interpretation and application of your contract. Senate Bill 5055 changed how arbitrators get selected and appointed for any discipline case involving a law enforcement officer, right? That is the state telling you, you're getting a new system. I don't care what's written down in your contract, and the state can do that. There's also going to be these subtle changes, right? You guys have Bill of Rights and contracts. Are there going to be some changes here about force investigations and force reporting that may have not on its face an impact on your contract, but maybe some downstream in-application type impacts on your contract? Sure, right? So you just got to keep an eye out for this stuff. The point is here, be active in how you're thinking about this stuff, right? Be thinking about the collective bargaining impacts of these laws. Otherwise, you're going to get blindsided, right? You're just going to walk in one day and you're going to log on to your MDC and you're going to be like, oh, look, I got a whole bunch of policies to read through. Force policy, pursuit policy, canine policy, crowd control policy, all changed. And you guys as an organization had no idea that those were coming down the pike, right? That's not a place where you don't want to be. Okay, any questions about some of those basic labor law concepts? No? Coffee kicking in yet? Question?
Here's something you need to work on, a form letter that goes to your guild, something from our attorneys groups. Many of us are either contracting with you or, Will or people that we know, and then that way we stay as a little bit more of a conformity and helping each other. And why aren't we doing that as a little bit of a way of handling this?
Yeah, so for those of you who missed the first part of the question is, Anil has really good ideas. Which is not exactly what he said. That's how it sort of filtered through my brain. Look, we, as organizations, we come to these conferences. They're annual conferences. We get good ideas. We get these good pointers. We take them home. We've got an organization like WACOPS, which is meant to try to knit together our organizations. But a lot of us a lot of the things that are happening on one side of the state may not be filtering over to the other side of the state in terms of how we as labor organizations should be responding to these changes because we're not talking to each other. And is there a way to get us to talk to each other? That is a great question and sort of $1 million questions. I'll just tell you that there's a couple dynamics there. One dynamic is bandwidth. Because this stuff is coming fast and heavy. I'll tell you personally, I can barely keep up myself. And this is what I do for a living, right? I work 3 6s a week, so I feel like I've got a good amount of time at my computer to really get this stuff going. But seriously, I mean, I can barely keep up. What I would encourage you guys to do is figure out a way to talk to each other. If you want to use WACOPS as some sort of triggering organization to say, hey, be aware of this, I think that's something you talk to the WACOPS board about and ask them as an organization to start helping spread this information. I will give WACOPS credit. They had, for example, when this whole social media declaration came out, they tried to put out information to try to assuage some concerns. They were working on the back end. The other piece is that there's just a bunch of different lawyers representing different groups, and lawyers hate each other, and we piss on each other's shoes all the time, and we say really mean things about each other, and that's not an excuse. That's not the way it should be, but it's a real dynamic. And then ethically, as a lawyer, I'll throw a third one in there. I just have to be careful about just throwing out legal advice willy-nilly, because the devil's in the details, right? I mean, if I say, for example, demand to bargain, but you've got a zipper clause in your contract, and a zipper clause is, pull your minds out of the gutter, everybody. A zipper clause, what actually is it's a contract clause that says you had your time to bargain and we don't have to bargain over anything else. My legal advice is going to change depending on the nature of your contract, right? And so sometimes it's hard on these issues to give blanket advice. But what I think is worth a conversation on an organizational level is there a way to at least communicate, for example, timelines, right? July 25th is when 1310 went into effect. Be ready for this, everybody. It's coming. That's a great idea, and I would certainly encourage you to take it to the leadership of the organization to talk about ways to get that communication out there. Okay, any other questions, or we'll start diving into the actual legislation itself? 1310. So these are in no particular order. I will give Chris Tracy a massive amount of credit here. He wrote the first draft of this. So I will do my best to do my best Chris impersonation and try to make sure I touch on a lot of the topics that I think Chris would have wanted to touch on. But you'll see stylistically as I walk through these pieces of legislation, what I'm doing is I'm identifying what the legislation did, and then transitioning to some things, food for thought type things, where I want to hear from you guys. So first, there is a new force standard under 1310, right? Peace officer may use physical force against a person when necessary to. Here's what I love about lawyers, man. Do you know punctuation can change a sentence massively to a lawyer? Note where the colon is. Okay. It's after to. Then you've got a list separated by semicolons. If I represent you and you get a red line back and Anil puts semicolons in, that means something to me, damn it, right? These semicolons mean something. Protect against criminal conduct where there is probable cause to make an arrest. Semicolon, effect an arrest. Prevented an escape is defined under another statute. Protect against imminent threat of death or bodily injury. What the hell does that mean? Does it mean you need probable cause to do any of those things after the colon? Or does probable cause only modify the first subclause as it relates to making an arrest? Second question for you. What's the difference between making an arrest and effecting an arrest? Here's my point. I have no fucking clue what that sentence means. Do you know who else has no idea what it means? The Attorney General. Teresa sent me probably my favorite lawyer letter I've read in a long time. It's my second favorite. My first favorite is a Cleveland Browns general counsel who got a letter from a season ticket holder. And this is in the 60s when Mad Men style lawyering. This is that's why I became a lawyer, because I was everybody sits around and drinks whiskey and types out really cool letters to each other. It's that's for me. Somebody was throwing paper airplanes, wrote a letter to the general counsel. General counsel responded and said, I just wanted to alert you that some asshole has stolen your letterhead and is sending stupid letters. And I was like, that is the best lawyer letter ever. Second best lawyer letter was the Attorney General's letter in response to 1310, where I think it was WASPIC and some other organizations reached out to the Attorney General's office and said the same thing in a far more professional manner. We don't understand this sentence. This could mean a whole bunch of different things, and in application can have a very serious change in how we police depending on how we read the sentence. You're the Attorney General. Short of a court, you're the ultimate interpreter and arbiter of we don't understand legislation. So can you help us out here and tell us what you mean? They respond and they said, sure. But that's going to take a super duper long time because we have to be really thorough and there's lots of books to read. And we probably won't get back to you until after the next legislative session starts. What do you think that they were hinting? Fix it yourself, goddammit. Man, we're working remotely. I haven't put closed-toed shoes on for 18 months. You expect me to go to a law library? F off. No, in all seriousness, the Attorney General is saying, look, if a body wrote legislation and everybody who's impacted by this, from police executives to rank and file representatives, are saying, we don't get it, go back to the legislature and tell them to fix it, right? I will tell you from Walkoff's standpoint, and Teresa and Jeff will tell you this too, that sentence is going to have to change, or there's going to have to be something added to the statute to clarify what that means so that you guys actually understand what it means, right? Because our Terry stop's gone, right? Is policing Mother May I can tell you some of the proponents of the legislation, Johnson in particular, wants that to be the case. But I don't think that's the outcome that the majority of the voting base in the state of Washington wants. Okay, what else happened? There are changes to the standard on deadly force. And I know you guys can read, but I'm reading this to you because I'm helping you tease apart where the trigger points are in analyzing the statute. Right? Here's what the text says. A peace officer may use deadly force against another person only when necessary to protect against an imminent threat of serious physical injury or death to the officer or another person. So imminent and necessary are defined, and in those definitions, totality of the circumstances are defined, right? So let's sort of peel this onion a little bit. Okay, what does imminent mean? Imminent means immediate. Well, motherfucker, why did you just say immediate? Right? Because look, based on the totality of the circumstances, we'll come back to that. Objectively reasonable, thank God they kept objectively reasonable. Remember our hierarchy of the laws? I think they would have had a huge issue if they moved away from the objectively reasonable police officer standard, because the U.S. Supreme Court in this great case called Graham v. Connor, I think you guys have heard of it, set the objectively reasonable police officer standard. Right? You've seen litigation in some other states like Minnesota, where there are actually some successful pieces of litigation saying that, look, legislatures, you went too far in changing statutory standards for the application of force. So, sigh of relief, at least you got the objectively reasonable police officer standard melded in here. Ability, opportunity, intent to immediately cause death or serious physical injury. Okay, so imminent means immediate. I will tell you, a lot of agencies do not consider those words synonymous. And I will tell you, all of your training is going to have to change. If there is a takeaway as an organization, the number one takeaway from all of these pieces of legislation I'm begging you to do is to go back to your training divisions, your training officers, and say, how are we going to train these new standards? Because play this out. What does that require? Before you can train something, what do you have to do? You got to understand it. And I guarantee you'll get stuck in the mud about what it means. But at least work to train officers, and we'll come back to this for their sake, because they have to articulate why they applied force under these new guidelines. And we're setting them up for failure, and I'm using the word we to include everybody in the law enforcement profession if we're not training people to this standard. Right? A lot of agencies are saying, we absolutely agree with you, we will train to those standards. Do you get that written down in an MOU? Maybe, maybe not. I don't particularly care at the end of the day. Do you know what I care about? Here's the pragmatic lawyer in front of you. Just get them trained. I don't care if you write it down or not. I don't care if you want to agree or disagree that training is something that the guild has the right to lock the employer down to in a legal agreement. I don't care. At the end of the day, do you know what your members care about? Not going to jail. Get the training in there. Okay. Necessary. So Washington's always had a very interesting necessity standard in the use of force. It's a piece of the use of force statute that has long predated these changes, right? So don't get freaked out that you're seeing, oh my God, we're seeing Seattle language. Necessary's always been on the books, right? No other reasonable alternatives were available type language on the books since like the 70s. But here's where it's being tweaked. Under the totality of the circumstances, you see it again, right? a reasonably effective alternative to the use of force does not exist, and the amount of force was reasonable and proportional to the threat. What does proportional mean? That's a Seattle word, by the way. Same, Jeff? Yeah. Here's a bargaining tip. I'll tell you what the layperson thinks proportional means and why you're going to want to bargain this into your policies. Do you know what a layperson thinks proportional means? Bring a knife to a knife fight. Is that how you're trained? Are you trained to use force to overcome resistance? Right? Anybody get into policing prior to 1984, 85? Any of you familiar with the pre-Graham force continuums? Have you guys seen those things? Tacoma PD still has one, which, by the way, they're unconstitutional, but we'll get around to fixing it. Right? Back in the day, there used to be these force continuums that had suspect behavior or what they were armed with, and then they had it was like a grid. And then they had the type of force you guys could use in response, right? And you would be trained to be like, look, they brought a knife. I bring a pistol, right? Because why? You want to keep yourself safe. You're going to try to get a hold of that situation as quickly as possible, and bringing a knife to a knife fight is an even fight. Probably not even even for you guys with reactionary curves, right? So if proportional could be read to mean bring a knife to a knife fight, here's how you fix it. You fix it in a definition in a policy, because the statute doesn't define it. This is from Vancouver's force policy that we negotiated, and we basically took Seattle's language, which in the second paragraph touches on this. You don't have to bring a knife to a knife fight. And we now have a standard for you all. We need a standard. They're defining everything in the damn statute except the new word, proportional. Totality of the circumstances. It's good that there's a definition of totality of the circumstances, but be aware in that definition what's there. Leading up to. What does that mean? Back in the day when I first started practicing in this arena, the moment force was used, think about it as a timeline. The moment force was used, we're analyzing the totality of the circumstances, right? That's changed. That changed with the whole I-940 and 1064 analysis, and it's changing with this statute. There is going to be an inquiry about the lead up, the tactics, the confrontation management, as some agencies call it. Right? Your folks better be ready to articulate all the things that happened ahead of time, not just what happened at the moment the force was applied and used. It's in the statute. Let's talk about articulation for a moment. Everything about policing is how you guys verbalize or write what you did and why you did it. And what you were writing about and what you were talking about has now expanded. You guys get that, right? Do not half-ass police reports to your members. I don't care how low level the use of force is. If there's an ability with your training divisions to go back to basic report writing, take out a crib sheet of these terms and tell officers and deputies, we expect you to articulate this stuff in your police reports. That is going to be immensely helpful to folks like me, folks like your city and county attorneys who are defending you guys in civil cases, and folks like PORAC call-out lawyers who are trying to help officers articulate deadly force applications in multi-tiered investigations. Because how you explain what you did and why you did it, and the word choice is going to be incredibly important. I litigated a case because the guy in his interview kept saying, I knew the suspect was armed. I knew he was armed. No, what he was trying to say is, I believed he was armed. But they fired him because of his grammar. They said he had a rigid mindset because from the outset, what turned out to be an unarmed civilian he knew was armed. He had predetermined his actions, right? That was an articulation failure. He just, terrible word choice. As simple as that. The other piece, which is a riddle me this Batman type category, because I don't know the answer to this yet, is remember that whole like big I-940 thing, and then we fixed it in the legislature, right, 1064, and the amount of effort and work WACOPS as an organization put into that? Now we have a new deadly force standard, and if you read those side by side, they don't fully match up. Which one applies? Now, I can tell you most prosecutors' offices still think that the existing statute at Chapter 9A applies, because when you read their letters, the prosecutor's declination letters, they're analyzing it under that statute. I don't know whether that has changed. I can tell you administratively and civilly on the downstream next steps of any deadly force encounter, this 1310 standard is going to come into play, right? And so I can tell you with the POR Act lawyers that I work with on call-outs is I've sent them this statute and said, I know you guys all have outlines where you're trying to hit these talking points, right? De-escalation, reasonable alternatives, less lethal alternatives, time, talk, and distance, whatever these guys are trained in those agencies about particular de-escalation tools and tactical lead-up to events. But now you're going to have to be considering words like proportional, right? That first statement to a criminal investigator will be carried by that officer or deputy throughout the other steps of that investigation, on the administrative side, on the civil side. Witness officers, same thing, right? What happens to a canine handler who deploys a canine as a use of force in an incident that thereafter turns into a deadly force encounter? Can their conduct, perhaps not being reviewed by a prosecutor, turn into an issue administratively and civilly? Yeah. Are they writing paper, or are they giving a statement to investigators as part of a critical incident response? Yeah. How many of you sat down or at least put eyes on the canine handler's report before he or she turned it in? All of you now when you go home, right? Because you know I got to make sure that that person's articulating why they use that level of force to fit all this junk now. Okay. Question?
Yeah, with the whole leading up to, do you know if it's like fair to include prior contact with those people?
With the whole component of leading up to being included in the entire circumstances, is that going to factor also like prior contact experiences that are with said subject?
Yes, I think so. To the degree that the officer, in their sort of thought process, considered that, right? In other words, at the time, like I think about this as sort of working backwards, right? So you've got the actual application of force, and then you're working backwards through the whole incident, right? And one of the questions I asked the officer is, did you ever have contact with that person? And if the answer is yes, was that a consideration downstream, right? So for example, I just worked on a shooting at a moving vehicle, officer-involved shooting case, and one of the shooters said, I had a run-in with that same dude with a shitty driving issue earlier that night. And so when I put two and two together and figured out it was the same dude and saw what he did when my first contact and I didn't pursue him and he was driving like a maniac, that factored into my consideration downstream, right? Now, if the person after the fact is like, boy, that name sounds familiar, and you run the name and you figure out that this guy's got an arrest record 7 pages long, but at the point in time that force was used, that was not a consideration, probably not going to come into the analysis. Does that make sense? Okay, there's also a generalized new duty of reasonable care in all force events, not just deadly force, any application of force. Incidentally, one of the things that you guys are going to want to talk to your agencies about is, what's the force line? Let me ask you this. Do your agencies consider resisted handcuffing a use of force? A lot of agencies do now, right? So think about it. All this stuff, just to put somebody in handcuffs, it's all going to come into play. So consider that. We're going to talk about force reporting later today, right? Consider that in your analysis of these pieces of legislation, just on the basic question, where's our force line drawn? If you're in an agency where resisted handcuffing is not a use of force, you may be looking at this stuff a little bit differently in those particular situations. Okay, so topically, what happened here? Well, they added a whole bunch of new language in here, and this stuff is going to be really important when it comes to articulation. Really important, because they're very heavy-handed standards. When possible, time and circumstances did not mean I had the opportunity to do something is the type of articulation you're going to have to make sure officers and deputies are articulating, right? I didn't have the time to go, yo, asshole, hold the machete. I'm going to call my Sarge, see if there's a 40 of it. Well, we can't use 40s. Maybe get somebody with a taser here, right? So in other words, the exigency of the circumstances are going to really dictate what this word possible means. Now, that's a good modifier for officers, right? Because that gives you the ability to explain why you couldn't do some of these things in real time. But what are the things that you have to do? You got to exhaust available and appropriate de-escalation tactics. Appropriate. Who's to say what's appropriate and inappropriate in that situation, right? Well, rather than have somebody else tell you what was appropriate or inappropriate, perhaps an approach here is to explain why, although you considered other tools, that they weren't used. Perhaps you called for a canine officer, but the canine officer was on the other side of the county and couldn't get there in less than 40 minutes, right? That may find itself in a police report. You're talking about what didn't happen and why it didn't happen. Another piece of that exhaustion doctrine is the possibility of walking away, right? You're going to see a common theme. I bet you walk out of this room and you say to yourself, well, shit, if you add up all of this legislation, what this really is they want us to depolice. That is exactly right. That is an overriding public policy goal of this legislation. They're trying to back you off of citizen contacts. Now, I can tell you to a person that the voting base in this state did not understand that. When you put these as individual pieces of legislation, I bet you, and Jeff would tell you, I bet you a lot of the legislators who voted on these as individual items did not understand that once you knit all this stuff together, what the outcomes are going to be, right? I guarantee you they didn't understand it, but that is the net effect of this. We'll come back to that notion of walking away in a second. When using physical force, use the least amount of force necessary to overcome resistance, right? This is where the definition of necessary comes in, right? What does necessary mean? No reasonable alternatives. It's all about articulation. Why time and circumstances didn't give you the ability or opportunity to have those other tools available to use. Question?
One thing that our training guys hit on is the change to the definition of necessary to where no reasonably effective alternative appeared to exist, and they took out appeared, so it does not exist now. And so that was the big thing, why we were articulating why things wouldn't work.
And that's a great point, right? And there you can see the subtlety, the art that went into just drafting that definition. One word, the removal of one word, changed the application of that standard pretty meaningfully, right? Because what the word appear invites what? 20/20 subjectivity, Monday morning quarterbacking, right? You take the word appear out of there, it now gives you the ability to say with a little bit more of a hard line edge, that wasn't reasonable, right? That person was attacking another human being with a blunt object. I had to intervene and stop that from happening. Standing back, calling for more cover officers was not a reasonable alternative in that moment. So that's a great pointer, a great tip there. Thank you. Terminate the use of force as soon as the necessity of such force ends. I'm less bothered about that because I think most training modules now have you, that's sort of being beaten into you, no pun intended. When possible, use available and appropriate less lethal alternatives before using deadly force. They're moving you to a deadly force as a last resort standard, right? You're not quite there, but you're getting pretty damn close. Available and appropriate. The availability of less lethal tools sure changed for you guys, didn't it? Since you guys all walk around with militarized beanbag guns, right? Make less lethal alternatives issued to the officer reasonably available for their use. That's a bargaining issue, folks, right? There's a lot of agencies in this state that still don't outfit all of their officers with tasers, for example. There's a lot of agencies. You set apart the whole, our 40 millimeter actual military equipment, set that off to the side. There's a majority of agencies don't have everybody rolling around with 40s, right? People are trained to and are assigned that tool. And maybe the sergeant at the beginning of shift tries to distribute those officers or deputies into various areas so at least geographically they're available. But they're not by default available. What about shields? All of you roll around with tactical shields in your cars? Not a lot of places. Maybe the sergeants get them in some places, right? But there's a statutory requirement to make those reasonably available for use. I think that's an opportunity. Now that's a soft area for bargaining, right? You can't necessarily dictate the purchase of equipment by an agency, but here's where you can use the tail to wag the dog and say, as an agency, you got to comply with the statute. We got to bump up the availability of less lethal tools in our agency if you're now being statutorily required to make them available. And in addition, for your officers and deputies, still, P.S., no qualified immunity legislation passed, so you guys are still on defense and indemnity rules. You're going to be paying money when plaintiff's attorneys ask, well, how come you didn't consider a taser? Well, we asked our chief to train everybody and deploy tasers on all officers, but he didn't want to do that because it costs money. I can guarantee you that city attorney who's defending that deposition just sort of crapped herself, right? Because they just tacked on a 0 to a civil liability case. So in other words, management has an interest here in making sure that there's these tools available, and you guys may actually work with management to make that happen, just using that one sentence as your leverage point. This law went into effect on July 25th. There is an easy way to rewrite force policies here, guys. Remember that whole hierarchy of law piece that we talked about? Can you write policy that does not include the word necessary in your local policy? No. Can you write a policy that does not include, when possible, use de-escalation? No. A consideration is simply to copy and paste the goddamn statute and make it your new force policy. Now, that necessitates you being willing to understand that there's ambiguity in that, but here's the message that your members need to understand is that's the new legal standard. That's what everybody else is holding you to. It seems only fair that from a policy standpoint, the agency should simply be holding you to those standards, right? So there may be an art and simplicity here, because if you actually try to take your existing force policy, which probably is on version like 263, and try to integrate in 1310, good luck to you, because I've tried it in a bunch of different places. And that thing just does not spit out well in terms of a good policy for an agency. Here's the piece that I want to talk about when it comes to 1310. This is what's intriguing to me. What has this new law, as it relates to this whole probable cause versus reasonable suspicion stuff, done locally in your policing responses to different types of calls for service? Are you guys just driving by stuff? Yeah? Are you guys getting out of your car and saying things like, I'll get to you in a second, we can't help you. I'm sorry. We need to gather some more information about who the suspect is before you're telling me that's the suspect. You're telling me that person hit you. I don't know that. So if that person walks away, I can't really do anything about it. What else are you hearing? This is important because there's something that's not legal that I want you guys to consider.
I work within an investigations unit, and I don't know if you're going to touch on this later on, or if I should just, it's kind of side sidebar item.
Go, man.
But right
You're on
along
the
this
slope.
topic, good example, you guys have probably heard of these things too. Child exploitation cases, we write search warrants like crazy. But clearly 1310 doesn't cover using force during a search warrant. So it means we can't hold somebody down to get buccal swabs. We can't handcuff them in the living room to take their computers and their phones. So we are literally like dead in the water with those types of cases. We're documenting that we're stuck. We can't do anything else. So
Let me ask you this, sir. Which agency are you from?
y'all,
Okay. With all this legislation and with that experience that you had, which grouping of folks, right? You've got the police reform advocates, you've got police chiefs and sheriffs advocates, you've got rank and file officer advocates, you've got other folks on state levels, AGs, governors, who are all lobbying for different pieces. Which voice is missing based on your experience in that very horrifying fact pattern?
clearly ours. We have a strange dynamic going on in Puyallup as well, because for anybody in local Pierce County probably knows that we're really pushing for a bond levy for a really nice, expensive new police department. Terrible timing because our administrators don't want this type of bad stuff going to our public, that we can't do things for you. And so we are strangely kind of the silent law enforcement agency, not putting out public PSAs saying this is what the legislation is doing, because we want people to like us and vote for our new building. So
That is a political conundrum. It's you guys have money in your in your local area, so
we do.
yes, there is a mark. Look, agencies are getting a black eye through all this, right? I mean, it's really hard to say, well, this is Olympia's fault, and to actually have that impact me and my family. Somebody said victim over here. Who said victim? Bingo. Yeah, I'm not discounting the fact that it is I mean, agencies look like shit out there right now, right? Like, well, how come they walked away from that? Hands are tied. Nobody likes that as an answer. But what about the victims? What about the crime victims? I'm going to tell, yes, he said, we only care about criminals in Washington. From a public policy standpoint, that's where a lot of this was driven, right? Bail reform, bond reform, whatever you want to call it. That's another view. What are prosecutors doing these days? How many cases are they flushing, right? Breaking the handle, they're flushing so hard. Crime victims. As organizations, think about the communications and PR aspect of this conversation, please. I'm not saying, I will tell you your chiefs and sheriffs are in much better positions to have meaningful outcomes with their communications and PR strategies. Why? Because they carry the weight of leadership in those conversations. I'm the locally elected sheriff, or in King County, the locally appointed sheriff, right? I am the police chief. They put me in this position to lead the public safety conversation in this community. As labor organizations, though, you guys have a voice, maybe an independent voice talking about this, or it may be a voice, a squeaky wheel voice talking to your PIOs saying, why the hell aren't we out there talking about this? Because I can tell you, there has been some good work out there done by agencies. A lot of them are in the King and Pierce County region, talking about the impact of 1310 on how policing actually happens to whom? To the people who are voters and to the people whose family members are crime victims. That shit hits home, and it hits home fast, right? That's where this tide is gonna have to turn politically, is the folks, when Jeff talks to a representative or a senator who has heard from the Federal Way area, Representative Johnson, their own police chief say, we can't protect our citizenry because Olympia passed a law that doesn't allow us to. That's going to have an impact, right? I would encourage all of you as organizations not to sit back and say to yourself, this sucks for us, but acknowledge the fact that it sucks for the public and figure out a way to use that as your leverage in this conversation, okay? A little PR tip for you all. I love the policing of profession. I think it is an honorable profession and it's a great profession. But I'll tell you a little dirty secret about public relations. People don't care about what you think if you're only talking about yourself. People care. It's human nature. It's the human condition. People care about topics because it impacts them. You guys have credibility out there as organizations. Your profession still has a massive amount of credibility. Don't listen to the media. You know that you do because you guys see it. You guys talk to the people, right? Take that little different approach about how to view an issue and vocalize it. As your police guild, we represent 100 police officers working in this agency. We hate the idea that we could not properly investigate that awful child sex crime because of a poorly thought out legislative change in Olympia, and we are working hard with our law enforcement partners around the state to fix this for you and your families. That is a much more powerful message than my job fucking sucks right now. Do we agree on that? Think about that for all of you. Okay, jumping right back into it. So considerations to keep in mind. Demand to bargain those force policy changes, pretty please. Don't get caught out on these important topics. Consider the way that de-escalation and all these various, last resort type motions in the statute are going to impact how things actually work in your agency, right? Because this is going to apply differently to an agency that has 18 officers on duty versus one that has 3 officers on duty when it comes to the availability of alternatives, for example. Consider just a couple of things here. There's downstream civil impacts of this stuff. There's considerations like the public duty doctrine. This was a Chris comment. What the public duty doctrine is, just as a reminder, is that to succeed on a tort claim in the state of Washington, you have to establish that the law enforcement officer owed you as a plaintiff individually a duty, right? So it's not that you just had a public duty to stop bad things from happening, but you had a duty to that person. And if you think about the way that this legislation is pushing from a public policy standpoint, it's actually saying that perhaps police don't have a duty to help people. I don't think that's the right place to be public policy-wise, but sort of legal liability-wise, that seems to be the message that's coming across. There was a question at the break, which was a good question, is, well, what is this whole conversation about governmental interest? How does that play into this? I can tell you that concept is coming from a lot of smart civil defense attorneys who are saying, look, the way that you articulate this and the way that this is getting translated out onto the street is you have to be able to establish that that person with that violation balanced against, in my use of force, how does the public and the government care about this? And it's a teeter-totter, right? That governmental interest may be really high and the individual rights to be free from interference of personal liberties may be really low. But in other situations, if you're a fish and wildlife officer and that person just has a minor angling violation and you're saying, hey, stop, and they're grabbing their stuff and they're hot-footing it away from the river, you may let them go and have to articulate, I let that person go because of the low governmental interest here. Right? It's basically what's the generalized consideration of me putting hands on somebody based on their behavior and what they're doing. I think it's been sort of bastardized in that I think it's being heightened in terms of consideration, and that's the only consideration. But that's where that concept comes from. With deadly force situations, obviously 1310 touches on deadly force situations. I don't want to rehash the conversation I had with you all last year in a Spokane casino, which incidentally is where I do my best work in casinos. Have your deadly force call-out plans down pat for your organization. If you're not on the POR Act list or any other legal defense fund list, you are, I think, negligent as an organization to your members. Legal defense plans are worth the $5 per month. I have just consumed $72 worth of this hotel's coffee, so I get, what is that math-wise, almost a full year of legal defense coverage, right? So that is a must-have. Consider for your organization where you're drawing the line between I'm going to lawyer somebody up versus I'm just going to have a guild rep assist them through this. Some agencies are still writing paper in these, like Spokane, which I found out when they took me out to dinner last night, but didn't buy me dinner. Boom. Just called you out, Stacy, in front of everybody. Love it. Power. I'm just kidding. I did get some deviled eggs for free. Yeah. Yeah. In all seriousness, though, look, there may be certain, I'll tell you how I approach it. I want to make sure anybody who's being asked to write paper or give a statement is at the very least conferring with a guild representative, and I'm hearing about it as the guild lawyer, because what I'm doing is I'm herding cats in the form of lawyers, right? If you got 3 shooters and 3 less lethal operators, depending on that when that less lethal was deployed, you may be having 6 lawyers called out to your incident, right? Man, Teresa gets to wrangle me. Teresa, if you had to wrangle 6 of me's, how'd that work, right? So in other words, you got to think about these things. Can you get 6 lawyers up at 3 o'clock in the morning? Because that tends to be statistically when most of these things happen. Just think about that stuff ahead of time, right? Because that articulation piece and those deadly force incidents, those critical incidents, are going to turn on these statements. And it's hugely important and frankly an easy thing to do as an organization to get your critical incident call-out plan down pat as an executive board. Okay. Some other miscellaneous stuff. I'm curious, have any of your agencies approved the use of the obstruction charge to perhaps get around some of the unintended consequences related to stops versus probable cause standards? Yes, love it. Okay.
Well, I guess, wait.
Microphone, my friend, microphone.
Whoa, came out of nowhere. So, maybe I'm completely off, because I feel like my opinion is different than everyone else in Snohomish County and at the agency. I actually don't think 1310 changes use of force for detention, for Terry stop. The House Bill 1310 clearly... I mean, it clearly in there says it repeals 103150, which is officer use of force when making arrest. But there's RCW 9816020 is the one that if you look at Washington Supreme Court, that's the one they use to analyze use of force on an investigative stop. And they've done it numerous times. And there's even, I think it's State v. Hendrickson, they say, hey, this is the RCW we use to evaluate an officer's use of force on detention, not 103150. And then, I mean, for ITAs, there's the Chapter 71, I don't remember the specific RCW, that talks about use of force on an ITA. So, I mean, I guess, because I've heard lots of people be like, well, we can't use of force on detention. Maybe I'm completely off, but that's not how I think it changed 103150, not all the other ones.
Okay. Who's on the other side of this fence?
Probably everyone.
Who would like to battle with our friend up front here on the other side of the fence and explain why they disagree or why their agency's instructions are you should disagree? Come on, man. I'm starting a grudge match. We make this stuff entertaining.
Yes, Mike. Yeah, I don't think anybody in here agrees with him. If you do, you don't understand the point of what all these laws were put in place for. even the lawyers that our cities across the state employ, they are extremely nervous about us using Terry stops. And especially obstruction like that. I would say under even the most limited of circumstances would I ever use that. I mean, who here now charges somebody with obstruction and that charge sticks? So you're already, for the however many years, been charging people with obstruction, and the prosecutors dump it immediately. So why would you use a charge that they're not going to convict somebody on anyways? They're telling you not to use it. They've been telling you not to use it, and these laws tell you not to use it. You're just hanging yourself out. Like, extreme. Yeah. I can't even explain how dangerous that would be.
So I love your heart in trying to do our job, but I guess for me, the way I look at it, is there are 4 prongs that say you can use force, and if you aren't in one of those, you're not able to use force. So the Terry stop, not using the argument for obstructing, but just you can't use it just for detention. My argument.
Come on, man. This is going to escalate to a fist fight, and you guys, that's it? That's all I got? Boy looks fit, man. He's ready to take people on. Let's go.
This is actually in the news because I'm from Pierce County Force Investigation Team, so it was actually published. The news is actually pretty good to us. I was happy that they didn't misquote my 60-page report. But the scenario was, I had a person, an actor, who's claiming to be a victim, who had a recording of my incident. I did a search warrant. First I asked him and his attorney, personal injury lawyer, can you give me the video, please? Please, to help verify your victim was there. They didn't do it. I wrote a warrant. Superior Court judge signed the warrant, one of our long-standing judges, reviewed it. We served the warrant, and with the attorney's advice, they refused it. Said, nope, we're not giving you the phone. So we just moved on. The prosecutor's office advice was, don't go reach out to the obstructing thing. We asked them to charge contempt, and they're like, we don't want to do that. Anyway, long story short, when we finally did the presentation, probably only a few weeks ago, all the prosecutors were all hot and mad about this attorney who basically defied the order. So I think it's a pretty clear contempt, and I believe they've charged him for that.
They did charge for contempt.
So, going back though to the darn phone thing, some of the options were, should we charge obstructing and use that to enforce an arrest, to get the phone, to get the evidence? Well, it's probably staleness issue now at this point, because it was a long time ago. But that discussion was had about, should we use obstructing? One of the things that came up, and of course this is discussions with our top prosecutors in Pierce County, as well as our judges. And the consensus was, if we introduce obstructing into the arrest to get the phone, now we have another crime that they're going to try to fruit of the poisonous tree on us to try to suppress the phone anyway, and yeah, we just dropped it. So they're still in limbo. They're still working on the contempt thing. They're still working on, we still want that phone, but yeah, it's a mess.
So I'm going to come back to the obstructing thing, because Chris Tracy and I thought that this was the silver bullet, and because Chris is a lawyer by trade also, so there was a chest bump at the end of the conversation. We thought we were so smart about this, but I'm actually curious about application. So to your point, I actually read the statute more like you do. But here's the
He didn't say he was right.
But you gotta let me get the second half of the sentence here. So here's the deal, guys. Think about this. You have a career on the line. You have a family on the line. I get to opine in my car when I'm talking to somebody on the phone, waxing poetic about it, right? In other words, lawyers, which I know pisses all of you off, your city and county attorneys who are defending you in these cases, are super risk averse, right? Now they're risk averse because it costs dollars for their client. I'm risk averse because if I'm wrong, do you know what happens to me? Nothing. Do you know what happens to you? Something big, probably, right? And so I am very defensive in the advice I'm giving on this statute, not because I actually agree with the reading personally. I disagree just because of punctuation. But it doesn't matter because you guys in your agencies, you've got city and county attorneys, you've got various AGs sort of giving personal opinions out there, and those are all pretty much in the camp of don't do it, right? Right? And so I'll get to your question in a second. So just think about it. My lens as a lawyer is from defending officers from bullshit charges and claims, and sometimes that means backing up off the line. Understand how unpopular that advice is. I mean, I had a general membership meeting that they started yelling at me, and I'm like, I didn't write the fucking thing. Why are you yelling at me, goddammit? I wouldn't have written it that way. But here's what my job as your union lawyer is to make sure you're not getting fired or indicted for something because you and I read the statute a certain way. Right? Well, Your Honor, according to what I thought after my second beer last night, that colon there sure changes the meaning of the sentence. That's not going to change anything in oral argument when there's a charging instrument on the line here. So back to this needs to be fixed legislatively, guys, right? Now understand, Jeff will tell you, if you open the door, there's all sorts of wonky things can happen. That pendulum can swing in the absolute opposite direction. So, you got to watch your periphery here. But to this cognitive dissonance point of, do I need probable cause to even say, hey, you stop? I'm not kidding, man. Sit down. If I need probable cause for that, and that very basic point in time is what we're trying to fix, maybe we can get that fixed. I think that changes a lot of the downstream impacts you guys are feeling out there with this legislation. You had a question, sir?
I think the confusion was Goodman and Johnson came out right after there was some pushback and said, but they have obstructing, they should be using that and charging it, blah, blah, blah. And I think that's where some of this got confused. They were very strong, and I'm like, nobody's charged. I mean, I've been a cop for 20 years. I'm like, the only time that's ever happened is when you use force and somebody, you're like, oh, you obstructed, off to jail you go, and it gets tossed.
Yeah, well,
they think we use it. I think they're just misinformed by whoever's telling them. Nobody uses that.
well, so here's the thing. The utility of a post-legislative session comment by the sponsors of the bill is about as worthy as me after my second beer being like, yo, well, this is what I think the statute says, right? In other words, it's absolutely meaningless. A court of law is going to read the text and context of the statute, and if that is unambiguous, that's what you own. If it's ambiguous, they're going to look at the legislative record, and in session is the comments are going to count, right? The post-legislative session comments by the sponsors of the bill, although perhaps a little bit more helpful to our cause, ain't going to help you in a court of law. That's, as a lawyer, my frustration is I don't care all this post-legislative chatter that's happening that Jeff and Teresa are getting 24/7 doesn't change the fact that the statute is being written and applied in a certain way. And if we're going to change course, there's one way to change course. Well, there's two ways to change course. State v. somebody who's a law enforcement officer, or legislative change. I prefer not to go the first route. Okay. Obstructing. I don't want to leave that yet. I'm really curious to see if agencies are using it. It sounded like some agencies are. There's two comments here. Ladies first.
One of the issues we've been having up in Walla County is we don't have room in our jail, and we're not even booking on known felonies because they're saying you can't do it. We're referring to the prosecutor, and they're sending charging documents to the person. So that also is one of the things like obstructing. I'm still not going to use force because I still can't. Especially if I know the person, like I know that's Jeff over there, and I'll just send him his ticket. So that's where we're running into issues is like, you can't at the back end do anything with them. So it's that known thing that we're kind of running up against.
Yeah, and that's a practical, bigger public safety system failures in our communities, right? There's no room in the jails. Did you hear there's a number of Florida jails that are closing just because of lack of staffing? They're just shutting them down. It's not like they're lacking inmates in Florida. They're just lacking staff to actually run the correctional facilities, so they're shutting them down. There's like reason number 7,963,000,000,000 why I don't live in Florida, right? The way that courts are handling bond and bail issues, right? The way prosecutors are charging this stuff. There's actually a holistic problem. We're looking at this sort of needlepoint style, but you're right. And that's changing the way you guys are policing. And a lot of credit's due to your members and sort of not only facing reality, but evolving their practices and saying, you know what? I'd love to get into a foot chase right now, but if I hook that bad boy up, he's going to get released and he's going to be right back out here in about 90 minutes. So maybe it's not worth writing the paper. Maybe it's not worth me getting hurt. I'm going to get smarter. I'm going to outsmart the dude. What about you? Your thought here?
So yeah, for the obstructing piece, I think the challenge is if obstructing is a viable option for using force, it basically nullifies that piece of the law. Because if obstructing is always an option, then we will always have PC for obstructing on a detention. So if they really only want us to be using force on probable cause situations, then obstructing, that's what, although you can read it a certain way, it just basically nullifies the law, which that's why our legal counsel for our department basically said don't use obstructing except when there's a governmental interest, and that's kind of where the gray area comes for us, is that trying to figure out what constitutes a governmental interest. They've talked about some of the severe type crimes. You've got a homicide, you've got a kidnapping, you've got a serious felony assault with a firearm, whatever it may be, up into, okay, well, is a DV assault for governmental interest where we should be using obstructing? Like we're trying to figure that out, and our department hasn't been super clear about every single situation that would require us the ability to use obstructing as workaround for the probable cause. So we're kind of in that strange area where they're saying, do the right thing, you have this option, and we'll protect you.
Yeah. Use your best judgment's always a terrible answer, right?
We're just running a situation where we have a divided interest as well. And I don't even want to say necessarily divided interest, but you have the interest of management who, has a duty to their constituents or to the public. And then you have the interest of labor who, we want to protect our members the best that we can. So they're offering up the obstruction as a workaround, and we're cautioning our members on. I'm not sure this is something that we want to use a workaround for. The gray area has been removed for us. It's not find a way to work in the gray.
And that's a good point to make to your members, right? Because whose ass is going to be over a flame if this gets tested as a viable avenue forward, right? It's going to be that arresting officer who's probably got a use of force somewhere mixed in there in that obstructing point in time, right? And so tread lightly with caution is a good warning to your members because, although I like the idea of using obstruction as a lawyer, your legal advisors are right to point out that, well, that's probably getting close to manipulating stuff because it certainly is not in line with the intent of the words on paper. I appreciate the fact that you guys as an organization are thinking for your members, saying, be careful here, guys. Just don't take it as a green light and go out there and go back to cowboy-style policing because that's not what this legislation is trying to do. There was a hand up in the back there, sir.
Right here.
Oh.
Yeah. Just to follow up on what Ben and Gavin were saying during our so-called training that we had, and I don't know if we discussed that. Our training for us was our training lieutenant, executive staff, the chief actually did show up, myself, 1 to 2 hours at roll call, hitting every roll call. That was the extent of our training on the 725 laws. I don't see any workarounds in the way that that language in the law is written. I think using our legal advisor started bringing things up kind of where Ben was going. If you think about the way they talk about barred felonies and some other stuff, with pursuits, almost applying that as the governmental interest of how to use obstructing to do that. I think it's a dangerous, slippery slope that we're going to get into. Most of our obstructing cases in Spokane County are tossed. I don't know what that's like everywhere else. Maybe you guys have wonderful jails that we don't have, and judges who are bargaining. They're tossed, and I don't think shit happens with them. So I don't know that they're bargained at all. So if we're using that charge as a way to use force to get around this law, I think we're going to end up with our asses in a sling, and at minimum decertified by whenever this stupid CJC criminal justice training thing stands up, or charged. Luckily, our chief decided to say, hey, we're not banning Terry stops. And initially I was really pissed about that. But actually by him saying that, if somebody steps out, we don't have to report to the training commission that somebody did it. That's actually a good thing for us. So my membership, by and large, has realized we're not going to do that, which is kind of a credit to who we hired. So.
Good points.
So I work for King County. I'm a detective sergeant. I have 4 of my detectives that do evictions for 2.2 million people. And I had to, yeah, it is a lot of evictions. So just to give you an idea of the scope of the level of work that we have, a typical month, I was just looking at stats a couple of weeks ago, we run about 300 evictions a month pre-COVID. And they come in all flavors. We deal with criminals, we deal with mentally ill, we deal with foreclosures, we get the and I'm sure other agencies have had this too. You get the suicides while you're at the door, it's, you know, the whole bit. I'm always looking for great communicators doing that kind of work. That's what we do. We rarely arrest people. You know, patrol knows if we go into a jurisdiction and there's a bunch of shitheads in there, Auburn or Kent or somebody or Federal Way, you know, they say, yeah, these guys are, you know, we'd like to run names or whatever. Yeah, you can do that, but we generally are just there to get them out. With that, what I have seen in evictions, and I started tracking this, is an increasing propensity for tenants to not leave. They're occupied. You always have to wonder, you know, why are they still there when you get there? And with that, we're getting a higher incidence of people not wanting to go once we breach the door. And so we're in this quandary now because of all this legislation. I'm telling my detectives, don't put your hands on them. We had to use obstruction, you know, occasionally. So I had to get special permission from our legal and our sheriff. It took them a month to make the decision, but they allowed us and our unit to use that as a last resort. But I can tell you just everything that's happened here, anecdotally, it's really backed up the work that we're doing. We're still doing evictions through the moratorium, the bad ones, and we're doing a lot more surveillance. We're waiting till people leave. I can give you story after story that this crazy legislation has interfered with the ability to get people out when you need to get them out. But it's a quandary every day. I mean, I'm running that tightrope constantly, telling my detectives, don't put your hands on anybody. We used to just grab them, you know. I mean, hey, you don't want to leave, just get out. We'll drag you out the front door, change the locks, we're gone. We're not doing that anymore. So it's really creating a log jam, and we're a unit that rarely arrests anybody. We go to great lengths to not do that. We don't have cages in our cars, we're unmarked. Again, I've got 4 detectives for 2.2 million people, and as the evictions moratorium ends, I'm kind of wondering what's going to happen here. I've been warning my command staff that there seems to be a higher propensity to not go when law enforcement says go.
And interesting experience. Terrible workload, by the way. 4, that's fantastic. Good staffing. And then, but that is a great example of where, back to this sort of communications PR piece, right? That is a perfect example of where if you just shift the story a little bit when you're talking outside. I mean, I'd love it if your sheriff actually got in front of folks who can make decisions here.
She'll never do it.
Look, man, let a man dream, my friend. That ability to tell that story from, look, there's somebody who owns this place who wants to get another tenant in there, and that another tenant could be somebody who is wanting to get back on their feet, who's wanting to get off the streets, right? You can tell a very good public story here, but our role as a sheriff's office in this piece of the story is one point in time, which is it's time to leave current tenant, and we can't do that. And that's hurting the system. It's not just economics. It turns out you got a homelessness problem in King County, and housing apparently is one of the solutions to it. And you guys are a cog in that housing machine, but that machine is getting slowed down by this piece of legislation, oddly enough, right? That story is, I think, where things could start shifting, right? Because Representative Johnson, who's in your county,
Yeah, we're evicting him.
yes, don't put hands on him, and
He got to stay, but his day's coming.
right. And so, but there's a story to be told there, right? Because look, as a resident, as somebody who is facing a crime, basically, right, with somebody who's trespassing in their housing unit, that means something. And that's the sort of firepower Jeff needs when he's going back down there next session and fixing all this, because he's said he's going to fix it all, by the way.
So along those same lines of communicating with the community about these new laws and the impact, and management having a different tact than maybe boots on the ground and a different view. And I've noticed like Tacoma has their own guild doing a lot of social media now. You know, our PIO is shut down regarding these new laws and the impact on us because the city says, nope, the mayor is going to put it out and it's only coming from our mayor. He will not allow our PIO to make some of those statements. So I guess a topic of discussion, I see that Tacoma's doing it a lot through their guild Facebook page or their union Facebook page. Are other agencies doing similar so that we can make our stories heard? And what kind of pushback are people getting regarding that?
Anybody's guild, association, union out there sort of stepping in and being sort of de facto PIO to talk externally about this issue? It's worth thinking about. A couple pointers. You guys, as guild representatives, as long as you're clearly identifying yourself and speaking in that capacity, have a lot of collective bargaining and First Amendment protections, right? I work at XYZ Police Department, but I'm here speaking to you today as a representative of our police guild, which is a labor organization that represents officers and sergeants in our police department. And we want to tell you a story, and it's a story about a crime victim. And it's a crime victim we couldn't help, not because we didn't want to, but because we couldn't anymore, right? If you're going to do something like that, there's some little pointers on the front end. But look, there's a gap to be filled, and if that means your organization wants to fill that gap, I don't think that's ideal, but that gap needs to be filled, and I'd encourage you to think about it. Tacoma is Tacoma's sourcing this material externally and funneling it through its social media pages, right? Their PIO should be doing that, God damn it, but they're not, so they filled the gap.
How many of you have heard that obstruction is an excuse or a justification to use force? I think everybody's heard that, right? That was going on prior to this legislation being passed. We heard it during session, and yet we have two of the sponsors saying, charge them with obstruction. I think they're going to be there when the calls come out to say that the only reason you used the obstruction charge was to justify the force that you used, which wasn't justified because it was because of X reason, disparate impact, right? The perception of obstruction from that angle, I think is not warranted, and I think somebody over here said we're going to be in a world of shit if we use obstruction all the time as a workaround to what the legislature said that they wanted to have occur. They said we do not want you using force in these situations, let them walk away. Which I think most everybody's doing right now, according to the interpretation of where we're at in the current law, which I think needs to be done. And again, Anil said it, and it's a common theme that I think you've heard from multiple speakers during this meeting. We're not our best advocates to let people know what the detriments are to these laws. It's the victims. It's the victim organizations. It's those people who are standing there saying, what do you mean you can't arrest a 14-year-old or interview a 14-year-old or whatever your crime is? That's the conduit that, as much as you guys can possibly do when you're talking with people when they go, what do you mean you can't do anything? You know, within your policies of agency and everything else, say, you know, I'm following the new laws that were passed. And it has to be credible. Because if we're going further than what the laws are actually saying, which happened over the last couple of months, where some of the media coverage was absolutely incorrect in saying that police officers cannot respond to crimes because of the new laws. There's nothing in these laws that say that you can't respond. Nothing at all. It's what you can do when you get there, right? So that takes some credibility out of the argument. So when there's arguments to be made on the detrimental impact of these laws, they have to be credible. They have to be understandable and relatable incidents that Joe Citizen's going to go, I don't like that. I don't feel safe. I don't feel like I got justice or my family got justice. So I throw that out there just for the obstruction thing because I hadn't heard that perception problem. And it's going to come back and say, well, we're going to take obstruction off the books.
Good points, Jeff. And you said it with far fewer words than I have been saying it, so damn. And so, speaking of words, we're on our first piece of legislation. So even though I threw Chris under the bus with all of his words, I just blabbed your ears off. And so I'm going to rapid fire here a little bit and move a little bit more quickly through some of these so I touch on them. But please interject with thoughts and questions. Next up in popularity for you all is 1054, which is the various tactics and munitions bans, right? So LVNRs and chokeholds are blanket prohibited. It's not prohibited except in deadly force encounters. It's a full-blown ban on these particular tactics. Again, I'm not telling you whether it's a good idea or a bad idea. I'm just telling you what happened. Prohibited military equipment. And then the way that the definition is written is that most shotguns, less lethal shotguns in 40 millimeters have been racked, right? But here we go.
We have an issue in Pierce County. In Pierce County, we have the chiefs have said it's the spirit of the law for less lethal, for 40s.
Sir, don't make me argue spirit of the law to anybody. So no, you bring up a good point. Look, there's a police guild that called me and said, look, so here's what our training division or training officers and our police chief said. They said, we think that the spirit of the law was such that they were talking about like, big ass, you bought a Humvee and then the thing had a high caliber machine gun on top, and that's what they meant by military equipment. And the spirit of the law could not have been a less lethal single projectile 40 millimeter that has no automatic function because it's a one-shot tool that we are carrying to do 1031's bidding, which is to add de-escalation tools out there on patrol. That makes sense. That's a public policy argument. Right? That's not going to help me when I look at that and I say, well, shit, man. The spirit of the law aside, it's written terribly, and that's got to get fixed. But right now, what that agency said is, now it's officer discretion. Now, do you know what I read into that is, well, we're not going to tell you yes or no. We're just going to pass the buck to you. And so my advice to that guild, which I thought was a poor management decision and a poor way to manage the workforce was, okay, so it's your decision. I can tell you what I would recommend the guild's position to be, which is don't carry the damn thing, because whose liability is it going to be ultimately, and whose stress is it going to be when they're questioning, well, why'd you deploy a 40? It's banned, right? And so, Teresa is having this conversation right now with CJTC, where CJTC is saying, well, look, we can promulgate a rule saying for our decertification considerations under the next one of the other slides we'll talk about, is that we will not consider the use of a 40 millimeter as violating this statute. And Teresa's response, spot on, is, well, look, it's not just you guys we're worried about, with all due respect, certification agency. Well, what about a criminal court? What about a civil court? What about an administrative review? When they're looking at this saying, do you guys have conformance to laws policies? Yeah. Do you get into administrative hot water if your chain of command says, well, you violated the law because you deployed a 40? But you told me it was a possibility. That was my judgment to use it. Yeah, but we reread the spirit of the law, and the spirit changed on us, right? So I don't want officers in that position. And so, again, this is a very defensive-minded approach and answer. I don't think it's right. I don't think that's what they actually intended, but that's not what they wrote, right? Because remember, how do courts look at things? This is what you wrote. If you didn't mean it, you should have written something different. This is what you wrote.
Yeah, we had an issue. So initially our chief wanted to go with the spirit of the law and leave the shotguns in the 40s, and we knew that was a terrible decision on his part. So we went to the county prosecutor, who's a conservative, kind of black and white letter of the law guy, and he said, I cannot use the letter of the law to exonerate an officer in a shooting, but then now use the spirit of the law to exonerate an officer for using a shotgun or a 40. And so we went back to the chief and said, hey, county prosecutor says you're wrong. He doesn't support you, so we shelved them. So I don't know, maybe for those of you who have administrators that are using the spirit, go to your county prosecutor and get them to go on record that they will follow this mystical spirit of the law.
Anil, on top of that, you got the state AG. You got the state AG, who is the legal advisor of Washington State Patrol, pulled all of their 40s and all of their shotguns out. Why? Because he read the same law. It's black and white. It's not really for our interpretation. Should not be doing workarounds. And all I hear is all these workarounds. I understand we're here to, I got on this job to help people. I want to help victims. That's why I got into this, and it's frustrating that what has happened here. This is not our fault. Okay? And so I think we need to, again, protect our membership, protect the people that we represent. We should not be looking for workarounds. That is dangerous. We're going to get our people incarcerated, and we're going to be served on.
And that's, look, as a labor organization, at the end of the day, that's your charge when you've got that hat on as a guild representative, right? You're taking care of your members. I'm with you. This is a very easy decision point for me, which is, I know it sucks, but don't carry the damn thing. And if your agency is saying it's fair game, ask them to do exactly what the Spokane folks did, which is get some fact verifying from other folks who are going to be looking at your conduct out there, because the spirit of the law, there's some 70s reference here that's like tickling at my brain, but I can't figure it out. But the spirit of the law is not going to help you when you're in front of a prosecutor looking at a charging decision. Teresa?
And just to further confuse this, excuse me, we spent a lot of time talking about how departments are handling this less lethal issue, right? And whether or not a 40 and all that, as we've just discussed. To be clear, we have at least one department in the state who has decided that shotguns are allowed and must be carried. So most people, when they see this, they think, well, this is obvious. This is clearly not allowed. There's no conflict between 1310 and 1054 on the matter of the shotgun. Now remember, this was an accident. We do not have any record to reflect that the legislature actually intended to take shotguns. But that is what the statute says in its plain face. And there should be no confusion there, and yet we have at least one department that has said, oh, no, you're going to keep your shotguns. So it's being interpreted interestingly from all angles across the state.
Good place to be. It means everybody in Olympia did some good, solid work there, right? 1054, canine deployment policies are going to go to some statewide best practices panel. So good luck to all you canine officers, because there's nothing like a bunch of people who've never actually seen a canine telling you how to handle your canine. That will turn out well. Pursuit policies are limited, so it's now a don't pursue except in incredibly narrow circumstances set of policies. And any sort of gas deployment is going to be limited to like riot situations, barricaded subjects, hostage situations. All of these are sort of ripe areas for at least paying attention to all the things we've talked about so far: policies, practices, training, De-escalation tools, if 40s have been benched, well, what other de-escalation tools do we have out there? How are we, look, this 1054 and 1310 can't be reconciled. So is it just simply we're going to reconcile this by benching the 40s and then we're going to have to figure out some other less lethal tools? We haven't talked about the duty to intervene, duty to report. I mean, that's a little bit of a wild card here. If you guys now have a statutory duty to report and you're in the camp of we shouldn't be carrying 40s and your partner's carrying a 40 and deploys it and you're like, well, that sucks for me. What am I supposed to do now? Right? Do I have to report that? The ban on chokeholds, LVNRs, VNRs, whatever you call them, don't do it. Don't use it. It's gone. It's not a tactic. You cannot use common law necessity defenses. Even though 1310 has, if you look at the text of 1310, there's a catch-all that you're allowed to use other levels of force if it's approved by your agency. But there is a more particularized, narrowly drawn statute on the books now that is a hard ban. So a general catch-all in my world as a lawyer can never overrule the narrowly drawn prohibition. They are banned. Don't use them. Nobody thought about the life and death situation where you may have to use one of these tactics. The ship has sailed. I don't want anybody getting charged because they're arguing, well, 1310 versus 1054. It's gone. Tell your members they're gone. If you can, figure out ways, if it's possible, to get on these canine work groups. Get your handlers out there. Things are going to change. As simple as, will a dog be allowed to go off leash is going to be a question that's going to be up for debate, right? How is that going to change the use of a canine in terms of actual deployments if you can't let the dog go off a leash? It's going to be a really long effing leash, I'll tell you that much. Other things, pursuit policies. The policies are going to be changed. I've been taking the path of least resistance here, which is just copy and paste the statute into the new pursuit policy. There's a really easy way to deal with this. CS gas, I think this is going to be protocol driven. You know, policy drafting, it's a very easy sort of small, there's limitations in there about who can authorize the use, right? It's easy to carve out sort of the tactical deployments for barricaded suspects and hostage situations. Those are easy carve outs. It's really the crowd control situation. Good luck getting a local official blessing any of these deployments, right? That's the whole goal here. They politicized a tactical tool. And so there you go. 5066, I know we're close to a break, so bear with me. This is the duty to intervene and report. This statute was written by a drunk idiot, okay? Because it is 2 sections long, and they couldn't even make them mirror each other. There's literally a feature on computers where you can copy and paste stuff. They set 2 different standards. It's crazy to me. The duty to intervene is for improper or excessive force. That includes the attempted use of force that may be excessive. But the duty to report is everything. You got to report wrongdoing, right? Wrongdoing is more broadly defined to include any violation of law or policy. Well, wait a minute. From a public policy standpoint, if I see somebody engaging in sexual harassment, I don't have to intervene and stop it, but I got to report it. That's the stupidest public policy ever, right? I mean, if you're actually requiring law enforcement officers to step in and say something and stop something, why wouldn't it be for all high levels of serious misconduct? Why is it just excessive force, right? From a public policy standpoint, it makes no sense, but there's the law for you. There's this exception for technical or de minimis things. In my mind, that means things like I don't have to report if somebody's late to roll call and the sergeant's there and saying, stay back, I'm going to talk to you about you being tardy. But what that means more broadly applied, who the hell knows? There is a reaffirmation of the prior legislative duty to render aid standards. And in terms of sort of an officer defense here, there is a nice piece of the statute that prohibits anybody from retaliating or discriminating against you or disciplining you for in good faith reporting any of these things. I'll tell you the duty to intervene statute is causing a lot of consternation in officers and deputies, and I get it, right? Well, how in a rapidly evolving situation do I know that use of force is going to be constitutionally excessive. Like, because that actual application of force took the sum total of like, well, less than a second, right? And so I think work with your agencies. When you're working with your agencies, be careful about how you draw those definitions, right? Some ideas out there are new or reasonably shouldn't have known, or what would lead a reasonable officer to know or should have known it was an excessive use of force. I think that probably passes muster because the objectively reasonable officer standard is still everywhere in statutes. But I think what would help folks downstream in your membership is actually understanding what my intervention obligations are. Be ready. The next, you guys, about when did de-escalation become the new four-letter word in your profession? 7-ish, 8 years ago, right? All this intervening, reporting stuff is the new phase of training. You guys are going to get tons of soft and touchy-feely type training on intervention and reporting, and your sort of moral and ethical obligation to do so. So just brace yourselves, it's coming. I've seen some of the training modules, and I just sort of giggled, and I was like, I can't wait for you to do that in a room full of 250 deputies. That's going to be awesome for you. Good luck, my friends. 12:23, then we'll take a break. This is for all of you who do custodial interrogation, so all of you do take a look at the statute. I will, in full admission, have not spent much time looking at the statute, but there's new recordation obligations at certain points of triggering events, like reading Miranda, right? That could trigger the custodial interrogation recordation obligation. And they managed to take what really is a simple concept and turn it into a 13-page bill, which is fantastic. You're welcome from the lawyering profession. And it's incredible. There's a ton of exceptions to the rule. If this hasn't been discussed in your agency, it's coming. I think it's either January 1 or July 1 of 22 that it triggers. I think it's January 1. You guys should be talking about this because there is, for your agencies that have body cams, I think body cams are more than sufficient to trigger all of this record, the obligations to record here. So this one, for all of you who pay attention to the actual, like the stuff that's happening in your agency in terms of policy and training writing, this is one to actually dust off and make sure the agency's paying attention to it. I haven't paid much attention to it because it's not as big of an impact on the sorts of things as a union side lawyer that I'm paying attention for you guys. I've read it a few times and I'm like, this is why I'm not a cop, man, because I have no idea what 90% of this stuff actually means in application, right? You guys who are actually out there conducting custodial interrogations on patrol or detectives, how does this all fit in? Like, can I transport somebody to a detective and make them do this damn thing? Or I'm like, how am I going to put them in my police car? Can't use obstructing. So, like, how is this going to happen? Are detectives going to roll out? Do I do the custodial interrogation and just on my body cam? Do the detectives have a body cam? You know, so there's a lot of real world application in your profession that I think this little statute that, frankly, not many people are paying attention to, will be paying attention to when it's time to kick it in.
Boy, it was like 2 days ago, caught our own policy where they put in there, and the law doesn't require it, but they put in there, shall advise of their Miranda rights at the beginning of the recording. And as a detective, we oftentimes don't do that on purpose as an investigative tool because Miranda is triggered by custody and interrogation. Well, we're not going to interrogate during custody, but we don't want a Miranda read yet until we get them. And so we're hashing that out now because we have to get that out of our policy because it's just not a good practice.
Yeah.
Right along those lines.
Yep, that's a great point. That sentence in the statute is a run-on sentence with 17 commas of different things that trigger all this, right? So you're going to actually, and this is where I think your city or county lawyers are going to have to take that out, turn that into bullet points, turn to the actual law enforcement professionals in the room and say, so I can read this, what does this mean in application? Because it is going to change the way you guys do custodial interrogations because there is a duty, basically a duty to warn of their rights pretty early on in the food chain here. And it triggers audio and visual, or in some cases audio only recordation. And so for your agencies that don't have detectives carrying body cams, be prepared to have that discussion because I could see that coming because that's an easy workaround or fix just in terms of a practical application.